This is IAQ Radio, Indoor Air Quality Radio, the voice of the indoor air quality industry, with your host, Radio Joe Hughes, and the Z-Man, Cliff Zlotnick. And now, Radio Joe Hughes.
Good day and welcome to IAQ Radio Plus. This week is episode number 505, and we welcome the restoration lawyer, Ed Cross. Please visit our Facebook and YouTube pages and leave a comment, a like, or a subscribe. You can also sign up for the weekly show announcement at iaqradio.com and download podcasts through Podbean or iTunes. And we have continuing education credits available for IICRC, ACAC. Email me at joe.hughes@iaqtraining.com.
IAQ Radio marquee sponsors are John Don Products, where restoration and abatement contractors shop. Visit them at jondon.com. That's jondon.com. Healthy Indoor Magazine, a free online digital magazine for industry professionals and consumers. Subscriptions are available at healthyindoors.com. Particles Plus, engineers and manufacturers feature rich particle counters, air quality monitoring, instrumentation, and vacuum pump technology. ParticlesPlus.com. Count on us.
And our newest sponsors are RIA, the Restoration Industry Association, the granddaddy of the restoration industry. Network with leaders. Learn more at restorationindustry.org. And AEML Laboratories. Free FedEx shipping, great pricing, same-day results, and never a rush fee. Learn more at aemlinc.com. Let's turn it over to the Z-Man for today's trivia question.
And now you can win a cool prize. It's time for the IAQ Radio Trivia question. Be the first to correctly answer. Simply email your answer to czlotnick@cs.com. Or if listening live, just text your answer from your computer. And now, here's the Z-Man with this week's IAQ Radio Trivia question.
Hello, everyone. Congratulations to Thomas Wesley Barnes III, ECS Southwest LLP in Greenville, South Carolina, for the first correct answer to last week's IAQ Radio Trivia question. He correctly identified Albert Camus as the philosopher, author, and journalist who said, "I rebel, therefore I exist." The IAQ Radio question for today, Friday, May 25, 2018, has been sponsored by Ideas, the solution chemistry company, creating unique solutions to odor removal, surface cleaning, and decontamination problems. Here is today's question. What is the legal term for a voluntary statement made under oath? Back to you, Joe.
Go ahead. Right. We have Ed Cross today, full-time restoration lawyer and part-time drummer. We rarely get to play some, live or some original music from the guests. So that was a little clip from Ed. We'll put that up on the blog. Ed's the restoration lawyer. He's built a successful law practice that specially caters to the needs of insurance damage repair contractors and remediators. He's got a bachelor's degree in speech communications with an emphasis on public speaking from Cal State. And his Juris Doctor degree was from Western State University in Fullerton, California. He is well known for his risk management advice, cleaning and restoration contracts, and related forms available for free and for purchase on his website, edcross.com. Welcome, Ed. Great to have you back.
Thank you, Joe. It's a pleasure to be here. You guys are getting better all the time. I love the addition of the video, getting high tech, right, Cliff?
There it is, man. High tech for a low tech kind of guy.
That's
why we have John and Joe has the studio, and I just need to click on, and I'm here. So,
John does an outstanding job, by the way.
He does.
John's our guy, man. That's John. You got to have faith. All right, Ed. Let's get a start on some restoration legal issues. Why don't we start with any current legal trends, recent case law that came out, anything that our listeners might be interested in learning more about on the restoration side of things?
Yeah, well, I find that owners are looking for more and more creative ways to try to prosecute their grievances against contractors. And one of the big trends that we've seen really accelerate here in California, particularly in the last year or so, is complaints against contractors' licenses. And one of the reasons owners really like to do this is that the state will prosecute these claims for free to the consumer. The California State Contractors License Board identifies itself as a consumer protection agency. It is essentially in the business of prosecuting contractors. The name Contractors State License Board is really kind of a misnomer because it is not the Contractors Board, it's the Anti-Contractors Board. And what they do is very aggressive, and in a complaint against a license, you don't have the same types of rights to defend yourself that you would have in civil court, where you've got a jury of your peers, or you have a judge who's being objective, who's going to listen to both sides of it. It doesn't work that way. You have an investigator who is in the business of prosecuting you, who will bring out an expert to come out and do an inspection. And with these inspections, they really get very, very aggressive with these. An example, there was an insurance claim regarding a piece of marble floor tile that had a red wine spill on it. It was stained, and they couldn't find a replacement tile for it. They couldn't find, it had been discontinued. They couldn't find it. And so the investigator for the state, found that the whole floor should be removed. And in the process of removing the floor, he figured we've got to take out the baseboards. And since the tile extended underneath the cabinets, we need to rip out all of the cabinets in the entire house. And if you're going to do that, you're probably going to damage the paint. So we need to repaint the entire interior. Next thing you know, we're basically remodeling almost all of the interior finishes of a property merely because one tile got stained. And investigators take the reports and estimates of these experts as the holy gospel. That becomes the law. That becomes the penalty that gets imposed. And unless the contractor pursues an appeal against that, that stands. And the contractor is ordered to pay this cost of repair, which we think in many instances is really overkill and really overblown. Nothing gets a contractor's attention as well as some sort of administrative action that potentially could put the contractor out of business. I had one I recently defended where there were some floor tiles that had come loose, and the investigator, the expert, found it would be like $65,000 or $75,000 to do all of the associated repairs. And because it was over $50,000, the license board decided that the proper remedy would be to revoke the guy's license, to prohibit him from ever being involved, from being with a licensed contractor as an RMO or an officer, basically putting the guy out of business. And it was really too aggressive and heavy-handed, because he had been in business for 25 years without any complaints, without any lawsuits. He had hundreds of satisfied customers. He had one set of floor tiles come loose, and they wanted to put him out of business. Well, we appealed that and got into some negotiations, and after a lot of wrangling, managed to successfully negotiate a settlement that allowed him to stay in business. And for most of that effort there, the homeowner didn't have to incur any attorney's fees.
Who does the appeal go to?
The appeal goes to an administrative law judge. And fortunately, we've been able to keep these matters from getting to that level. There are ways that they can be settled. And once there is an accusation filed, which is the document that's filed to suspend or revoke someone's license, the matter then goes to the Attorney General's office. And we hope that the Attorney General's office will take a fresh look at it. But the license board is essentially the client of the Attorney General. And if the license board wants some particular result, I don't think the Attorney General's office can overrule that. But we end up negotiating with the Attorney General's office. But, it lacks due process. The Attorney General's office gets to set the hearing date, okay? And there's no other area of law that I know of where an advocate for one side gets to control the procedure of the matter. And it's really unfair, and these laws need to be revisited.
Ed, this is California specific, correct?
Yeah, that's my experience that I'm referring to, and the other consumer-friendly states as well, I imagine, have similar types of issues going there.
Now, I know you do contracts at least for Florida and for other states as well.
Right.
What is Florida a consumer-friendly state, or is it are you familiar with that?
If you look at the fact that attorney's fees can be shifted in an action arising from an assignment of benefits in that aspect, I think it is kind of a consumer friendly state. We don't have a statute like that here, and I wish we did.
Go ahead.
Ed, are the contractors in California doing anything in order to fight this? Or are they organizing? Is this something that's new, or it's something that's been going on for a while?
No, it's not something that's new. A couple of years ago, I tried to encourage the California contractors to get organized and accumulate some funds to hire a lobbyist. And some of the bigger ones stepped up, but there simply weren't enough numbers of people willing to make a commitment to that effort. It's not an enormous amount of money, but as we've learned from past experiences, it's difficult to get this industry organized in a way so that financial resources can be pooled in some sort of joint legal effort, unlike industries such as the auto repair industry, which successfully fought back against the insurance companies and, the standardized pricing and all of that. And they actually won some cases and made some progress with that. And frankly, I don't understand why the restoration industry remains disjointed. And you guys might be able to answer that question better than I could.
But who would they be fighting? I mean, if it's a government thing, I don't know that you can fight the government. Typically lobbyists are trying to prevent the law, from going in. They're not necessarily trying to change the government.
Yeah, so basically you get a lobbyist on board who has some relationships in Congress and knows which representatives and Congress people would be most open to that type of legislation, and you get that representative to sponsor the legislation and try to bring it to the floor for a vote. And that's how law gets made.
Mm-hmm.
And that's an interesting area. So in California, if you're a restoration contractor, you have to be licensed as a renovation contractor, or how does that work? And is it similar? I mean, around the country, I know there's going to be different rules in different states, but generally speaking, don't restoration contractors have to register as a home improvement contractor or something along those lines?
Yes, in California, if you're going to be doing demolition or removal of drywall, baseboards, cabinetry, that sort of thing, you need to have a contractor's license. Most of them have a B license, which is essentially a general contractor's license. We also have a specialty license here for asbestos abatement. And the law about what you can do under a general contractor's license is worded in kind of a confusing way. And I get calls fairly often from people asking if they can do asbestos abatement in California under a general contractor's license, and the answer is yes. Or you can do it under an asbestos abatement license. We have a lot of specialty sub-classifications here, but the B license is the right one in California. You don't need it if you're just doing extraction, cleaning, dehumidification. But if you're altering, if you're cutting and removing, like taking out cabinets, for example, for more than $500, you need a contractor's license for that.
I see. I want to move on to another topic here, which is who is the client or who is the customer for a restoration contractor? I mean, I think I know the answer, but then you get a lot of times our restoration listeners kind of get put in the middle of difficult situations. Ultimately, who is their customer?
This is a discussion that has been raging on in this industry for many, many years now. And there are some good arguments that people make about it. But at the end of the day, from my perspective as a lawyer, the customer, as identified in the contract, is the person who is ultimately responsible for making payment of any amount not covered by the insurance company. That's not to say that the relationship with the adjuster or the insurance company is unimportant. It's extremely important. They're a vital stakeholder on many of these losses, and they need to be respected as such. Okay, but at the end of the day, the legal duty goes to the customer, which is typically the building owner. Sometimes it's a tenant, but a number of restoration contractors get themselves in trouble because they fail to properly identify the customer. They fail to get the contract with the right person, or a property manager will sign the contract, or a house sitter or a neighbor or a family member will sign it. And they get involved in some pretty expensive litigation later on trying to figure out which party actually owes the legal duty to the contractor for payment. And even though there's an expectation on the part of the owner and the contractor that the money will come from the insurance company, nonetheless, the customer is the person who signs the contract for the actual work, not a preferred vendor contract, but to do the work, which is typically going to be the owner or the occupant of that structure.
Okay, let me get another kind of set the table question here, and then I want to go into the TPA issue a little bit more in a moment. But before we do, how restoration companies, they obviously need to make a fair profit, but what is a fair profit, legally speaking, Ed?
Yeah, well, there isn't really any law on that per se, Joe. And, a lot of times adjusters or customers, they want to talk about the percentage of profit that a contractor is charging on a particular job. And I feel very strongly that in the vast majority of cases, the actual percentage is not relevant at all. I mean, let's think about it. The percentage of profit on a job depends on the individual efficiency and buying power of the contractor. I represent restorers of all shapes and sizes, from the small mom and pops up to the very biggest names in the industry. And if a company works hard, provides good service, has a lot of satisfied customers, and is able to grow to a point where they amass more buying power and can purchase materials and subcontract services at a lower price, their margin is going to go up, and they're absolutely entitled to that larger margin. Okay, the easier way to avoid this problem is to use a fixed price lump sum contract wherever possible. And that doesn't necessarily change the obligation of the insurance company to pay a higher price, but it does give the contractor legal rights to prosecute and collect that particular dollar amount.
I know that has been an area that Cliff has commented on quite a bit, the fixed price lump sum price. And I think sometimes that people feel like they're kind of stuck with using a insurance company's program for determining the pricing. And it sounds to me like you're saying, no, that's not necessarily the case. But, I guess they would then maybe argue back that, well, that's, I got to try and keep my relationship with the insurance companies too, because, as you said earlier, yeah, my customer is the person that signed the contract, but ultimately, I still have to have a good reputation with the insurance industry. How do you suggest contractors approach that kind of difficult issue, lump sum, fixed price versus going with a program?
Yeah, as a communications major, for me, so much of it goes back to good communications and disclosure. And if all of the different stakeholders can decide on a price and agree up front as to how the job is going to get charged, I think that really solves, 85 or 90% of the problems. Most of the collection issues that I deal with are ones where contractors send out a bill that causes sticker shock. And, if they don't like the preferred vendor pricing program, go ahead and address that up front when you're signing up for the program. And then when they come back later and try to chisel down the prices, that's something, that you can relate back to. You can reference the original agreement. And I'm afraid that some contractors are so eager to increase their volume that they get overcommitted and they'll agree to things that they can't really perform economically, that doesn't work out for them. So, I think good, candid communications up front are really helpful. And a lot of project managers and estimators, they're trying to close deals. I understand that completely. They want to sign up jobs, and a lot of them are on commissions, and they don't want to talk about money. But you know what? We need to be ruthless right up front. We need to talk about the dollars. This is what the price is, because if we're not going to get paid and there's going to be a problem or there's going to be sticker shock later on, we're better off just not taking the job.
Okay, interesting. Cliff, do you have any follow-up on that?
I think one of the big mistakes that contractors make, particularly in the area of drawing, is they don't necessarily look at economies of scale. And I think that's one of the reasons why they run into sticker shock. An air mover may cost $250. They're renting it for $25 a day. It happens to be on this particular job for 30 days. And, there's a little bit of sticker shock there because the client could buy 3 of them for the price they're paying to rent 1. So I think in certain situations, economies of scale need to be they'll need to be discussed. I reviewed it. I was a consultant on a project and reviewed it, and they had a bill for deodorization. And the bill for deodorizing this building was in excess of $100,000. And they had 3 people there doing it for 8 hours. And what was crazy is they were using Xactimate pricing, because Xactimate said it was half a cent a cubic foot or whatever, the price for residential. They didn't have a commercial rate. And I think they ended up collecting it, which in my opinion was a little much, for 3 hours and a little bit of equipment and chemical. But
but back to this point about a customer saying, well, we could have gone ahead and purchased the equipment. Fine, go ahead and purchase the equipment. If you're going to hire a professional restoration company who has been trained, who has sent out technicians to get IICRC certified, and they're going to pay the insurance, and they're going to be subjected to all of the different risks that are involved in performing one of these jobs, and they're going to learn psychrometrics, and they're going to adjust the equipment, and they're going to monitor it. You're entitled to get paid for that. And it goes back to the point I made before. You come up with the price ahead of time. You say, okay, we're going to charge $25 a day for this particular piece of equipment. They're not compelled to agree to that. Okay, they could say, no, we're going to go buy our own, or we don't want to do it, or we'll just let the building dry naturally, or whatever they want to do. But I push really hard against these arguments. Well, we could have just gone ahead and bought it. Fine, go ahead and buy one. If you hire us to do it, you got to pay for it.
Okay.
And another topic I want to put out here before halftime, let's see, it's 11:20. We got 4 minutes to halftime, is the assignment of benefits. And, that's been a huge issue, especially for our Florida restoration people, direction to pay clauses. Is this something that's specific to Florida? Maybe will it be coming to other states? Is this something that you're dealing with? And how do you suggest contractors, what they do with this?
Yeah. The only state that I know of offhand that has the attorney fee shifting provision is in Florida. It may be in other states. But in most states, a policyholder can assign the rights to insurance policy benefits over to a contractor. And this is very different from a direction of pay. A lot of times contractors will contact me and they'll say that they have an assignment of benefits in their contract. And what I see is something that says the insurance company is instructed to send the check to the contractor. Okay, that's not an assignment of benefits. That's merely an instruction as to how to make out the check. Okay, an assignment of benefits is a legal provision that transfers the legal right and title to insurance policy benefits over to the contractor. And if it's drafted properly, it's going to be irrevocable. What that does is allows the contractor in most states, probably not Texas, for example, but in most other states, to prosecute a claim directly against the insurance company. In other words, the holder of the assignment, who is the contractor, steps into the shoes of the insured. And I have continued to update and modify my assignment of benefits, and now I have a supercharged assignment of benefits clause, which includes an instruction in there that says that the insurance company is authorized to release all information regarding the status of the claim over to the contractor, and the insured waives the privacy rights, excuse me. And so the contractor can then have this direct line of communication with the insurance company, because the contractor then becomes the claimant. The contractor becomes the insured. But if the contractor has failed to put the insurance company on notice of the assignment of benefits, then it doesn't do any good. I've handled a number of cases recently where the insurance company sent the money to the policyholder who skipped with the cash. We were able to get the insurance company to pay twice on those claims because they were put on notice of the assignment of benefits. That should be done formally with a letter where it's tendered, which is insurance vernacular for submitting a claim. You tender the assignment over to the insurance company because they have to be on notice of it. And the assignment of benefits should also include a provision that says that the policyholder is transferring the right to sue the insurance company for breach of contract, negligence, and insurance bad faith over to the contractor. It really puts the contractor in the driver's seat there, and has been a very effective way to help accelerate communications and collections.
What about the consumer, Ed? I mean, would you, let's turn this around a little bit. If you were representing a consumer in Florida for whatever reason, or a state, California, and they were asked to sign an assignment of benefits, what would you recommend they watch out for?
Well, the assignment of benefits should not be broader than the scope of services that the contractor is providing. It should go without saying that when this assignment is made, they're not transferring the right to collect, for example, additional living expenses or replacement cost for personal property. Some consumers bristle at the idea of an assignment without realizing that just about every time they go into a doctor's office, they're signing in an assignment of insurance policy benefits, giving the doctor the right to collect directly from the insurance company. It's actually a very common part of business in the United States. And I would not be concerned about it. I want the contractor to work on prosecuting that invoice with my insurance company.
And I would imagine in car repair is the same thing. I don't remember paying them.
Yeah. I don't know the answer to that, if they have an assignment or not.
Okay.
It would be, I could see how they would want one, but even though you have an assignment of benefits, you also want to have a contract with your customer that allows you to collect from the customer, because that's your contractual right there. That's very important. People get so wrapped up in the insurance side of it that they distract everyone away from the fact that the customer is making a financial obligation. If the insurance company doesn't pay and the contractor goes to collect directly from the customer over and over and over again, they say, I didn't hire you. They forget that they sign a contract. They were under stress because of the loss. And they weren't expecting to pay the contractor, particularly if the contractor has been referred by the insurance company. They call the insurance company, a contractor shows up. In their minds, the contractor is working for the insurance company. It goes back to what I said before. It's about communications and accurately controlling the expectations of the customer and really helping them understand what the process is, and then following up with a letter or an email to remind them, I am working for you. I'm going to collaborate with your insurance company, but you're still responsible for this.
Interesting. Cliff, did you have a follow-up on that?
I did, just a little one, Joe. I would think that any state that has public adjusters operating in it is going to have an assignment of benefits provision, because that's how these guys get paid. And it seems that they don't have the collection issues that we have. But there was a really good comment by a listener, actually, that I'd like to read. It says that the assignment's the only real security to provide service otherwise unsecured to an unknown consumer on an emergency basis. We don't know if they have the money equity other than the insurance contract.
Yeah, exactly. And I've had lawyers challenge assignments of benefits on a whole bunch of different grounds, and sometimes they'll say, well, it's not supported by consideration. Consideration is a bargain for exchange. To get a contractual right, the law expects you to sacrifice something for it, for there to be an exchange there. And what I've written in my new supercharged assignment of benefits is something that basically says that the assignment is given in consideration for the contractor's agreement to perform services without the expectation of immediate payment from the customer. And we don't say this, but in essence, the contractor is extending credit terms over to the customer. All right, I'm going to do this work, and for a little while, for a short period of time, whatever, 15 days or whatever it is, I'm not going to expect payment from you if you don't have it, and we're working on the insurance claim.
Excellent.
Interesting. All right. We will be back. We have to stop and thank our sponsors with the restoration lawyer, Ed Cross, in about 90 seconds.
IAQ Radio would like to thank our association sponsors, the Indoor Air Quality Association, a nonprofit multidisciplinary organization dedicated to promoting the exchange of indoor environmental information through education and research. Visit them at iaqa.org. Gray Wolf Sensing Solutions, who use advanced sensor software technology and embedded computers to provide superior environmental test instrumentation. Visit them, wolfsense.com. IAQ marquee sponsors are John Don Products, where restoration and abatement contractors shop. Visit them at jondon.com. That's JONDON.com. Healthy Indoor Magazine, a free online digital magazine for industry professionals and consumers. Subscriptions are available at healthyindoors.com. Particles Plus, engineers and manufacturers feature rich particle counters, air quality monitoring, instrumentation, and vacuum pump technology. ParticlesPlus.com. Count on us.
Okay, we're back with Ed Cross. Ed, I've got a text question here. Can you pull that over here where I can see it, John? From a listener, and it looks like an interesting one with respect to getting paid here. Let's see. How can a contractor best expedite payment releases when a third-party mortgage company is a party on a payment check from the insurance company? I would imagine that happens fairly often.
You're a master of understatement, my friend. Yeah, it happens all the time. The mortgage companies out there are holding billions of dollars of contractors' money, and in a lot of instances are not in any great hurry to release it. I think it's important, number one, to get what I call a mortgage information release signed at the outset, explaining to the customer that in all likelihood, if it's a larger job, that their home loan documents would require a payment to name the mortgage holder on any insurance loss drafts for that property. So we have them sign an authorization that allows the contractor to communicate directly with the mortgage company, and that also includes a release of privacy rights, so you can check on the status of that. We strongly prefer, of course, to have the contractor named as a joint payee on the check, and if we have a good relationship with the customer, which is the overarching point I want to leave everybody with today, maintain good relationships with your customers, even if it requires a little bit of sacrifice along the way, so that when the check comes in, they will notify the contractor of it, and the insured should endorse the check and hand it over to the contractor. But a lot of contractors make mistakes because they call the mortgage holder, and the mortgage holder says, endorse it and send the check to us, and they do it. And the contractor has lost a lot of control there. He who holds the cash holds the power, right? So what do? I send a nice friendly letter to the mortgage company, first off notifying them of the loss, because a lot of times their collateral has been damaged and they don't even know it, letting them know that there are insurance proceeds, and I send them a photocopy of the check together with a contract that says that if we send them the check, they will immediately endorse it and send it back to us. And if they refuse to sign that contract, we do not send them the check, and we have the right to go to court to get a court order for the mortgage company to sign the check. And what a lot of mortgage companies fail to understand is that the law in a number of states, including California, gives a contractor superior rights over the rights of the mortgage company for those particular funds. And this has been the law in California for decades, and a lot of people who are in the mortgage and home loan industry don't know anything about this. And so the simple concept is that if the contractor has provided services and substantially completed the work, and insurance proceeds have been paid, it would be manifestly unfair to allow a mortgage company to keep the money and the work. That's like a double recovery for them. Mm-hmm. A lot of these mortgage documents say that the mortgage company is allowed to withhold those funds if the mortgage is in arrears. What they don't know, many of them, is that the California courts have said, no, it doesn't matter if the mortgage is in arrears, because the right of the contractor trumps the right of the mortgage company to those particular funds. Because again, the contractor has improved the collateral, in most cases bringing it to a superior condition than what it was in before the loss. And you can't let the mortgage company keep the money for that. So we lay out the law, we give them the citations to those particular authorities with a photocopy of the check, and we've had great success with that. They've signed it, and we've turned around that money pretty fast. And if you've got a mechanic's lien and you have a signed certificate of satisfaction, that really helps to expedite the process, because the mortgage company is really motivated to have any encumbrances removed from the title for its collateral.
Interesting. Cliff, do you have any follow-up on that?
I don't. I thought it was well done.
All right. Let me, I want to jump to another interesting topic here. We had the Restoration Rebels on last week, and it was a fun show. And, they've got a big group on Facebook, probably 2,500 people that, they've got a little network, essentially. I don't know the proper term for it. It's not like a not-for-profit or anything like that. It's a network of people on Facebook. And they were talking a little bit about, bad reviews and online reviews. And then I saw something else after the show that made me, it was a legal case somewhere about a contractor getting a bad review and then, suing the person that gave them the bad review when, they were able to show that, this person was probably not doing so in the best faith. What kind of recourse does a contractor have if you go online and somebody starts to rip you about whatever? What do you recommend people do when that type of situation comes up?
There have been some lawsuits for defamation over bad Yelp reviews, for example. Defamation claims are actually a little bit more difficult to prove than most people realize. One of the big problems with pursuing a defamation claim is that when something is presented as an opinion, it's not considered defamatory. When something is presented as a fact, when it is actually false, and that statement causes some damage or is the type of statement that would harm someone's reputation, then in theory, there would be a right to sue for defamation there. But one argument is that by nature, a review site such as Yelp is opinion. And in the United States, we have this wonderful thing called the First Amendment, freedom of speech, and it provides a lot of protection for people to talk. And, I have seen some contractors get hurt because people will create fake Yelp identities in order to put disparaging reviews about people up there. And so you don't know who to go after. As a practical matter, prosecuting a case like that is very expensive. And, determining what your damages are is something that is very, very speculative. You need to go into court with some convincing evidence, some sort of meaningful calculation as to what your monetary harm is, unless it's the kind of case that's called defamation per se, which is a certain category of accusations made against someone, for example, that they've engaged in criminal behavior. Okay, that's something where damages might be presumed, but there's even exceptions to that if the person is a public figure, for example. So, defamation cases are not easy, and at the end of the day, what do you really have from it other than a big bill from your lawyer? I have some clients who have successfully negotiated the removal or the alteration of a negative review. So Mrs. Jones is unhappy with her cabinets. Maybe you can call Mrs. Jones and do something to broker a deal with her so she'll turn her 1-star review into a 5-star review if that's the only thing she was unhappy about. And I have a client who just did this recently. There's a lot of discussion out there online about how to remove these negative reviews. But there's a lot of protection that they have because of the First Amendment. I think it can be unwise to threaten companies like Yelp or Google with legal action and that you're going to take them to court. They live in court. They're giant companies. I also think that retaliation is not a good idea. It's likely to get the company in even more trouble. You don't want to get into a flame war with these people, and you certainly don't want to track them down on other social media and breathe new life into it and extend the drama. I've seen some comments from some businesses that are very unemotional, very factual statements that are made as a polite and respectful rebuttal. And I think done properly, that can help. But sometimes it can reinvigorate a war, which you want to avoid. So I wish I had a great solution for the bad review problem, but I don't. I just hope that the review sites, particularly Yelp, will get a lot more aggressive about filtering out the fake accounts. And somebody gets unhappy and they get aggressive, they might create 5 fake identities and put up 5 fake reviews over one thing. I mean, you get a mountain out of a molehill when that happens.
Sure. That's an interesting topic there. Cliff, do you have a follow-up?
Yeah, I do, Joe. I have some experience with it. Kind of before Yelp and Google, we had a situation where a product we made was used by a contractor, on an insurance claim, and supposedly the policyholder, got sick, and the goldfish turned into nitrogenous ooze, and the kids got cancer. I mean, it went crazy, and she claimed to have lost. She claimed to have been pregnant and had a miscarriage in a McDonald's, and unfortunately, when she got off the toilet flushed itself, and the evidence went down the drain. I mean, it was absolutely crazy. And naturally, we reacted to it because, number one, we were involved in a product liability litigation with her. And secondly, we had the claim. And what happened was we sued her for libel, slander, defamation, and so on and so forth. And we actually won the case. And I actually got money, but I didn't get a lot of money. I ended up getting $3,000. And the reason I got the $3,000, which came nowhere near covering my legal fees, but the reason that I only got that money is, as Ed touched upon, I was not able to prove that I had a financial loss. Mm-hmm. My business actually increased during that period of time rather than decreasing. And the reason it increased is, we were working harder at it. I had no idea who would see it. I had no idea what effect it would have on our business. So we were even more helpful to people. So, but it was a crazy, crazy experience.
It was a Pyrrhic victory.
Pardon me?
It was a Pyrrhic victory. You won the battle but lost the war.
Well, it was all right. The thing was, I would have taken her to the ends of the earth. I mean, it was just, it just was. I mean, she was just absolutely crazy. I mean, the stuff that she would put on the internet would read like a Stephen King novel. I mean, it was just unbelievable.
Well, I got another text question from a listener, and I'm going to I think we answered it, but I want to change it around a little bit. He was asking, if you have contract documents for other states besides, California and Florida, and I think you do. But my question is, how much different do they have to be on a state-by-state basis?
Well, some states, particularly the ones who are more consumer friendly, like California and Hawaii, for example, have some fairly involved consumer protection statutes. A lot of contractors make a big mistake by just pulling some generic forms down off the internet, and they get in big trouble for doing that. And in some states, it's actually a crime, particularly for residential projects. Okay, a bunch of states have requirements that you state the the exact price in dollars and cents as a lump sum. In other words, time and materials contracts are illegal in California for residential work. I've said it many times before, and I'll keep on saying it. You have to disclose reliability insurance, carriers' contact information. You have to state a completion date, and just about every state has a specific disclosure requirement for the contractor's mechanics lien laws. And a lot of times these disclosures have to come verbatim right out of a statute. It's vitally important that a contractor has the contract reviewed by a lawyer who's licensed in that jurisdiction. Most states, for example, have a right of rescission where a consumer can cancel a contract within 3 days. The right of rescission has to be disclosed following a specific statutory disclosure. And if it's wrong, there's a violation and the contractor's license could be in jeopardy, and the contractor may end up working for free because the customer could have rights to cancel the contract and make a claim that no compensation is due, or at least that the contract price goes out the window and is unenforceable.
I think you understand this kind of comment question that I got from one of the restoration rebels. They wanted to talk a little bit about tortious interference by carriers, and I probably mangled the word tortious again, but
perfect.
Can we talk a little bit about that?
Sure. There is a tort claim that can be made in civil court called tortious interference with contract. All right. And that's when someone negligently or intentionally damages someone else's contractual or business relationships, and that damage causes some harm. I have not seen this litigated. I haven't seen lawsuits actually filed for this, but if an insurance adjuster were to come out and do what they frequently do and tell the customer that the contractor that they've hired has prices that are too high or does work that's not good or whatever, and they encourage that owner to basically breach a contract with the contractor, then the contractor could have a right to sue that insurance company or perhaps a consultant or, an industrial hygienist, if you will, for interference with contractual relations. All right. If I have a contract right, that's an asset that I own. And if somebody comes in and damages that, then, they have some potential liability exposure for that. There is natural apprehension about suing insurance companies. They have virtually unlimited resources. They are not shy about litigation, and they fight cases very, very hard in most instances. And I think that's one of the big reasons why we don't see these sorts of lawsuits filed. I see threats made. So, the contractor will tell the adjuster, hold on a second, you're interfering with my contract. You're not allowed to do that. And, the big point we need to stay focused on is the adjuster actually has a very, very limited set of rights. The adjuster is just there to determine how much money the insurance company is going to pay, all right? And figure out in that adjuster's view what the usual and customary cost is for that particular job. The adjuster cannot, must not, shall not control the project, control the contracting process, or intermeddle in the contractor's relationship with the customer.
Does that also hold after the fact? So say your invoice goes to someone else for review.
Right. So the reviewer, let's say, contacts the insured and says, your contractor charged too much and you shouldn't pay this. All right. If you can show that that's been done wrongfully, and the adjuster is interfering with the contract rights, in theory, there's a right to sue the insurance company for tortious interference with contractual relations.
Interesting. I've got one more, and we're running low on time here, Ed. So I'm going to round it up. Cliff, I was going to ask the question that was texted in. Do you have one for a final thought for Ed?
No, let's use the text one. That's fine.
Okay, so it says here that my state, thanks, John. If my state requires a 3-day right of rescission, how do I protect myself on an emergency water mitigation? That's a tough one there. You've got 3 days, you're into it, you're almost done with the job by the time they, this is over, this 3-day right of rescission. Ed?
Yeah. In California, and I suspect in most states, there is a procedure to allow a waiver of the right to cancel. And the procedure needs to be followed correctly according to the statute. In California, the law says you have a right to cancel these contracts within 3 days unless the work is urgent, there is an emergency situation, the circumstances of the emergency are described in writing by the customer, the right of rescission is disclosed in writing to the customer, and the customer then waives the right to cancel because of the emergency circumstances and does it in writing, acknowledging receipt of the notice of the right. So I know I have the right to cancel this, but I really want you to start the work right now, and I know you don't want to start the work if I'm going to let you work for 3 days and then cancel and then try to get out of paying entirely. So, but the big mistake a lot of restorers make is they incorrectly presume that there is no right of rescission if it is an emergency. That's wrong. The right of rescission is always there, but if there is an emergency, the customer can waive that right if it's done knowingly and done in writing, following the procedure set out in the statute.
Ed, I've got two quick, one's a quick one. Do you have the waiver in your contract documents about adjuster control? Yes, is the answer. And the last one I've got.
Adjuster control?
I'm sorry.
About the right of rescission.
Controlling. So it goes back to the statement about the adjuster must not control or direct a project.
Yeah, that's not something we put into a contract because that's between the contractor and the insurance company. Our contracts don't deal with that side of the relationship. But if an adjuster is getting involved, acting like a project superintendent, then they're liable just like a contractor. If something goes wrong on the job, and the contractor faced with that should contact a lawyer to send a letter to the insurance company to say, back off, you're overstepping. Just adjust the claim. You deal with numbers. Let us do the job.
I think that's a great way to end this one, Ed. I love it. Although I do want to ask, is there anything we missed that you'd like to add? I want to thank you again for joining us. This is always so much fun having you on here.
That's very kind of you. I think most legal problems can be prevented in the restoration industry with good communications, good documentation, and good follow-through. The customer relationships are even more important than good quality workmanship. If you do a really good job, but you haven't adequately explained and displayed that to the customer may not understand. Things can go sideways, and collection problems can result from it. Be a good active listener and develop a relationship of trust with the customer, and you should be able to avoid a lot of legal problems.
Ed Cross, the restoration lawyer, thanks so much for joining us. It's always a pleasure to have you on, and people can learn more at edcross.com. You must have gotten that one pretty early on in the internet world, huh?
I did, long time ago.
Once again, thanks so much for joining us. This is Radio Joe Hughes saying thanks to this week's guest, Ed Cross. John, you got to have faith at the controls. My co-host, the Z-Man, Cliff Zlotnick. We will be on a little Memorial Day break next week. No show next week, but we will be back in 2 weeks. And we've just got a bang-up lineup set up already for June. I've got a tremendous lineup of guests. So we will be back in 2 weeks live with the next broadcast of IAQ Radio Plus.
For IAQ Radio, I'm Spike Reed saying thanks for listening.